a little-known provision, quietly embedded within a newly proposed legislative package referred to informally as the One Big Beautiful Bill, has sparked significant legal and constitutional concerns. Tucked deep within the text is a clause that, if enacted, could fundamentally alter the balance of power between the federal courts and the executive branch. At the heart of the matter lies a single line, overlooked by many, that would effectively limit the court's ability to enforce certain rulings. The language in question, located in Section 7302, restricts the use of appropriated federal funds for enforcing contempt citations in cases where an injunction or restraining order was issued without the posting of a security bond. While the wording may appear technical, the implications are anything but. Traditionally, the courts have served as a critical safeguard within the government structure, intervening when laws are broken, rights are violated, or overreach is suspected. Judges possess the authority to issue orders, and when those are ignored, they can hold individuals or agencies in contempt. This enforcement mechanism ensures that legal rulings carry weight. However, under the terms of this new clause, if a security deposit wasn't submitted at the outset of the injunction request, as is often the case for everyday Americans lacking the financial resources, then the courts would lose their power to enforce compliance. Even when a judge rules in favor of a citizen whose rights were infringed, the order could remain unenforced. The government, in such cases, could legally ignore the judgment. This development arrives during a time when concerns have already been raised over previous instances in which court orders directed at executive agencies were not followed. 1. Particular case involving a legal resident mistakenly deported despite judicial intervention highlights the potential consequences. The situation remained unresolved, even after high-level court directives were issued. Legal scholars and constitutional experts have noted that the ability of the courts to enforce rulings is not merely procedural, it is foundational. Without the power to uphold their decisions, the judiciary becomes largely symbolic. Laws, in that scenario, become suggestions rather than enforceable standards. What's particularly troubling is that this clause was introduced without open public debate, buried within a much broader legislative proposal. This strategic placement makes it more difficult for individual lawmakers to object without opposing the entire package. The tactic is not new, but the stakes this time extend far beyond budgetary allocations or partisan disagreement. At issue is whether any future president, regardless of party, could operate without meaningful judicial oversight. Should this provision pass into law, it could establish a precedent allowing the executive branch to circumvent legal checks. For citizens, this means that even if a court sides with them in a legal dispute against the government, meaningful resolution might remain out of reach. Rights could be affirmed on paper, but not upheld in practice. This change would also impact the legislative branch. Congressional investigations, hearings, and subpoenas rely on courts for enforcement. Without that support, oversight mechanisms weaken, reducing accountability across the board. Questions about the legality of such a provision have already been raised. Can Congress truly strip the judiciary of its enforcement power in this way? Some legal experts argue that it directly undermines the constitutional structure of checks and balances. While the bill has narrowly cleared the House, it now moves to the Senate, where the outcome remains uncertain. For now, awareness of this issue is crucial. The public's understanding and engagement could shape what happens next. Whether this proposal is supported or opposed, the conversation it has sparked centers on a fundamental principle: the rule of law. In a system designed to prevent the concentration of power, the courts were never intended to be ignored. And if that protection fades, the question remains: what recourse is left?